Assalamualaikum warahmatullahi wabarakatuh. Hi to all judgment and to all everyone. May it please the court, my name is Nur Amira Shazani binti Muhammad Yazid, counsel for the respondent, that is Yaya as plaintiff.
Assalamualaikum, may it please court. My name is Nur Farhana binti Samri, counsel for the appellants, that is Maidan Senda Berhad as a defendant. For the case, Yaya went shopping at Maidan Senda Berhad and wanted to buy a VCD Harry Potter display on the shelf. Yaya looked at the price tag. It cost Rm15 ringgit. Yaya went to the cashier counter to pay for the VCD. The cashier informed her the actual price of the item was Rm45 ringgit and not Rm15 ringgit. Yaya insisted that Maidan Senda Berhad to sell the VCD to her at Rm15 ringgit as there was a contract between them, advised both parties.
For the issue in the case between Yaya and Maidan Senda Berhad is whether the contract between Yaya and Maidan Senda Berhad is valid, void or voidable because the display of the item at the rug is not an offer. For the answer issue from plaintiff is the contract between Yaya and Maidan Senda Berhad is valid because the price on the VCD indicated the actual price as well as indicate the offer and not the invitation.
For the answer issue, the contract between Yaya and Maidan Senda Berhad is void because the display of the VCD at the rug is not on offer, but an invitation to trade.
The law that can be manipulated in this case between Yaya and Maidan Senda Berhad is an offer. Definition of offer is a proposal or offer is a promise to do something or promise not to do something made by the offer.
This case use definition is invitation to trade. Definition for invitation to trade is not a proposal but a sort of preliminary communication which pass between the parties at the stage of negotiation and not capable of being turned into a contract. It invites the other party to make an offer.
Next, what is the section? We use a section based on section 2A when Yaya signified to Maidan Senda Berhad his willingness to buy a VCD with a view to obtaining the asset of Maidan Senda Berhad. To the acta, Yaya is said to make a proposal.
For this contract, I, as a defendant, use section 2A of Contract Acta 1950 relating to our case when Maidan Senda Berhad signified to Yaya to abstain from doing anything with a view to obtain the essence of Yaya, Maidan Senda Berhad said to make a proposal.
The case Yaya and Maidan Senda Berhad seem like case Haider v. Rich 1840. What happened in the case is the court dismissed the claim and held that there was no binding contract for the farm between Mr. Haider and Mr. Rich. It was stated that when a counter offer is made, this supersedes and destroys the original offer. This original offer is no longer available or on the table. In this case, when Mr. Haider offered $915, he cancelled the $1,000 offer and could not backtrack and accept.
The case Yaya and Maidan is same case Fishy v. Bell. The case Fishy v. Bell same because the case fishy female heard that displaying a flat knife with a price tag in the shop window was an invitation to trade and not an offer for sale.
For the rebuttal is strong evidence to win in the case is that Maiden Sedihan Berhad employer have been careless while doing the job, where they don't double check on the price tag on each item. It seemed to have deceived their customer. As a customer, Yaya has the right to make a low price offer compared to the actual price. This is because it is a mistake and negligence of the part of Maiden Sedihan Berhad employers. And indirectly, Yaya should get justice for this case.
I, as a defendant, have a rebuttal. My rebuttal is Maiden Senda Berhad is a DVD store, so owner Maiden Senda Berhad should place an invitation to trade at a price tag so that it can attract customers and not the intention of Maiden Senda Berhad to cheat. If Yaya see the price on the DVD is different from the price in other stores, Yaya should first ask the Maiden Senda Berhad to ensure the actual price. So here, that Maiden Senda Berhad is not guilty because Maiden Senda Berhad only does to get sale for its DVD only, and the actions of Maiden Senda Berhad are not categorized as a criminal because Maiden Senda Berhad only puts the price on DVD belonging to Maiden Senda Berhad.
So the conclusion from Yaya as plaintiff is in the case between Yaya and Maiden Sedihan Berhad is Yaya can sue the Maiden because Maiden put the wrong price tag in the right. Based on definition of offer is a proposal or offer is promise to do something made by the offer. So Yaya reserves the right to offer a cheaper price for the VCD. This is because it's the negligence of the Maiden work who misplace the price tag and will make any customer who seem to be interested in the price offer. Based on section 2A, when Yaya signified to Maiden Sedihan Berhad his willingness to buy a VCD, with a view to obtaining the essence of Maiden Sedihan Berhad to the acta, Yaya said to make a proposal. Based on decision made in case Hyder v. Rich 1840, the court should held there was a breach. So, between Yaya and Maiden Sedihan Berhad, when Yaya make a new bid, the original bid will delete. In this case, when Yaya offer Rm15 ringgit, she cancelled the Rm45 ringgit offer and include not backtrack and accept. In this case, the Maiden needs to be honest in the selling price so that there is no dispute between Yaya and Maiden.
Conclusion: in this case, the contract between Yaya and Maiden Senda Berhad is void because the display of the VCD at the rack is not an offer but an invitation to trade. Based on the definition relating to our case, invitation to trade is not a proposal but a sort of preliminary communication which passed between the Yaya and Maiden Senda Berhad at the stage of negotiation and not capable of being turned into a contract. It invites Yaya to make an offer. Based on section 2A of Contract Acta 1950 relating to our case, when Maiden Senda Berhad signifies to Yaya to abstain from doing anything with a view to obtain the essence of Yaya, Maiden Senda Berhad said to make a proposal. Based on decision made in case Fishing Football, the court should hold that in accordance with the general principles of contract law, the display of the knife was not an offer of sale, but merely an invitation to trade. So, between Yaya and Mother Senda Berhad, VCD for sale at Mother Senda Berhad was not an offer of sale, but merely an invitation to trade. This is because it is only to attract the attention of customer. In this case, Yaya needs to accept that the price tag is an invitation to trade, and Yaya needs to make sure the actual price before deciding to buy so that there is not dispute between the two parties.